Hello, my name's Nicole. I'm with the Family Liberation Front, and today we're going to talk about the CHFS Parents' Rights and Responsibilities Manual that should be provided to every parent when your child is removed from your care. Unfortunately, most parents never see this document. They never are allowed to discuss it, and when they are entitled to discuss it, they end up being misinformed about what their actual rights are. I know that certainly happened in my case. So, when your child is removed from your care, there are still rights that you have. Just because your child is in foster care does not mean that you stop being a parent. So, this booklet should be given to you. As of the first page, you can see it offers all of the contact spaces for all the contact information. You'll see the caseworker, supervisor, intake worker, regional office contact, a spot for your attorney, and for the guardian ad litem. It is very rare that parents in Kentucky are made aware of any of this information. You might know your caseworker's name. You might get lucky and have their supervisor's name, but I have yet to meet anybody who knows the intake worker's name, a regional office contact, and they usually don't find out who the guardian ad litem is until they are in court. Most parents also aren't aware of how to contact the ombudsman's office in Kentucky. Now, there's another video that I will do specifically on the Kentucky Ombudsman for CHFS. What we're going to go through today are your rights. Now, these rights apply to you if your child is with a relative, if your child is in foster care, in a group home, or in any other kind of setting that is out of your care. As long as your parental rights have not been terminated, these rights apply to you. So you have the right to be treated with respect. You have the right to be heard and to help make decisions about your family. You have the right to know about your child's physical and mental health. You have the right to know about your child's school progress and participate in decisions concerning their educational needs. You have the right to provide consent to and attend your child's physical and mental health appointment. You have the right to visit and maintain contact with your child. You have the right to determine your child's religious affiliation, and you have the right to file a service appeal if you are not satisfied with your case plan or visitation agreement. So let's go through these. The right to be treated with respect. I'm not sure where you are in your case, but I can tell you that the right to be treated with respect by cabinet workers is very flagrantly abused. We'll discuss in a different video the proper way to communicate with your caseworker, with their supervisor, and with all of their partner service providers. Just be aware that if you are not recording your interactions with your caseworker, any cabinet members, or any of their partner service providers, then you have no protection. Kentucky is a one-party recording state, which means that you are allowed to record without informing the other person that you are recording them as long as you are in the conversation. So you cannot leave a recording device in a room, walk out of that room, and record other people's conversations. That is a felony. But if you are part of the conversation, you are the one party to that conversation and you are allowed to record. I encourage every single parent who has any kind of contact with Child Protective Services in Kentucky to record every interaction. The right to be heard and help make decisions about your family. They will often come to you and just inform you of what is happening or ignore the request that you made. I encourage you to communicate with these people by email. If you have to speak to them on the phone, record the conversation. I discourage texting. Email. It has their individual assigned email address on it. It can be easily copied, forwarded, and downloaded and printed. And any concerns that you have about your child or about your family, you need to submit respectfully and politely as possible to the caseworker, to the supervisors, to your attorneys, so that they know that you have these concerns and it's documented. So if you just verbally say that there's an issue or a problem, they can just come back and say nobody ever said anything. So email it. So you have the right to be heard and you have the right to help make decisions about your family. You have the right to know about your child's physical and mental health. Now, this is a big one. Through our group, we have talked to a lot of families, and it is almost not heard of that parents are told when their child is ill, taken to the doctor, has an appointment for the dentist, for a therapist, has to be taken to a clinic or the emergency room, has medications prescribed, whether it be an antibiotic or anything else that the child needs. This is important that you stand on this right and document your efforts to be involved in this, because down the road, if they move to terminate your rights, the very first thing that they're going to say in that petition is that you did not participate. Even though they didn't give you the information, they denied you the information, they will still say that you did not participate, that you didn't show up to doctor's appointments, that you didn't ask questions about mental health, that you didn't inquire or attend IEP meetings at the schools or parent-teacher meetings. So it's important that you document your requests to know about your children's physical and mental health and check in regularly with your caseworker so that there is a clear paper trail that you participated and tried to be involved. The right to know about your child's school progress and participate in decisions concerning their educational needs. This is another right that parents are very commonly denied. They will have IEP meetings, they will have parent teacher meetings, they will have all different kinds of meetings. Your children will have to change schools most of the time. If your children get moved from one foster home to another foster home, you might get an email saying, well, your kid's going to this school now. But you should be, and you are, allowed to speak to their teachers, to speak to the guidance counselor, to be involved in any IEP meetings, to follow up about their any behavior issues they're having in school. Now, the schools, like many of the providers, will tell you that they can't tell you anything that because your child's in foster care. This is not true. Now, it's not the schools and the providers' fault. They have been trained to this by the cabinet. So, in order for you to get access to any of this information and to participate with your children in school and their education, you will need to send those emails to your caseworker, CC their supervisor, CC your attorney, and let them know that you want to and intend to be involved in your child's education. The same thing applies to the next right, the right to provide consent to and attend your child's physical and mental health appointments. They will fight this tooth and nail. The cabinet will do everything that they can to keep you from having access to medical and mental health appointments, test results, notes, and medication choices. They will, your children, if they get sick, they won't tell you. If your children are diagnosed with ADHD or PTSD or something like that, you won't find out until court. They will medicate your child and not tell you what they're being medicated with. They will block access to all treatment and care, especially mental health. You won't find out anything that's going on with your child until 2 or 3 days before court or in the courtroom where they'll land it on you like a bombshell. You need to make sure you're writing these emails to your caseworker, CCing it to the supervisor, and also to your attorney that you are standing on your right to attend and provide consent to your child's physical and mental health appointments. The right to visit and maintain contact with your child. Now, this is largely going to be determined by the judge. Now, the judge is going to go off of whatever the caseworker and the supervisor write in their review note, what their recommendations are. They're going to base this largely on any therapy providers and what they recommend. But you have the right to visit and maintain contact with your child. In my particular case, the judge disallowed visits based on therapy recommendations, and no one told me that I was allowed to write my children. I should have been writing my children. I had kept a journal. I can't give them the journal pages, but when I attempted to address this with the caseworker, I was told I was not entitled to any contact at all with my children except for the supervised CPS office visits as the judge allowed them. That was not true. For the entire time that my children have been in care, I could have been sending them pictures, writing them letters, and maintaining contact with them that way. Now, this is another sticking point. If your family gets promoted to a termination of parental rights hearing, they will say that you did not maintain contact with your child, despite denying you contact with your child. So you need to document your efforts. When you write to your children, make sure that the letters are encouraging and happy and supportive of your children's needs. Your children are scared and they're confused, and they're probably having a psychological and emotional reaction from being taken away from you. So just make sure you don't include anything in the letters that relate to the case, that say anything negative about the cabinet or about the foster parents. Request that your child write you back, send you pictures, do whatever it is that you can do to help ease your child and help them get through this situation. Do not let the cabinet tell you that you are not allowed to write your children the way they did me. I found out just, over 2 years in, and I found out a month ago that I could write my children because I was specifically told I couldn't. It wasn't true then, and I've been writing my children since. The right to determine your child's religious affiliation. Okay, my children are currently going to church. Now, while I don't have a particular dislike of any religion, I also don't know what dogma this particular congregation is promoting. And nobody told me that my children were going to church. I found out during an office visit when they told me that this family apparently doesn't celebrate Halloween because it is demonology. So that doesn't align with my particular beliefs, but I decided not to pursue it. But you do have the right to determine your child's religious affiliation. If your children are being taken to church or to some sort of religious activity that you disagree with, you need to be informed of that, and you need to be have a voice and a say in that. They can't just take your child anywhere they want to and teach them something that is counter to your particular values. Now, the right to file a service appeal if you are not satisfied with your case plan or visitation agreement. So that sounds real good, but how exactly do you file a service appeal if you're not satisfied with your case plan or visitation agreement? Nobody tells you that. Nobody gives you the resource to actually do that. So, how does one go about that? Well, there are forms that CHFS has that they do not provide to you. You have to find them yourselves. And in one of the next videos, I will show you where that service appeal form is. and we'll go through it line by line, just like we're going through this, so that you understand the time frames for filling these things out, because they put time limits on everything, the information that you need to include, the language that it would be most appropriate for you to use, and what the process is after you submit this. Now, the responsibility side. Um, Information about relatives on both the mother's side of the family and the father's side of the family using a specific form provided by your social worker during or after the 72-hour removal hearing. Now, I didn't receive this form, and the majority of people I know didn't receive this form. I didn't know that this form existed. So, in order for your child to be placed with a family member, that family member must be vetted and investigated and approved by the cabinet before they can be placed. So, you'll have to provide the name, contact information, as much information as you have for this person for the cabinet to contact them, so that they can do the background check, they can do the home study, and then they have to provide a written and valid reason why your child is not allowed to stay with a family member. Now, all of these things are important because down the road, when it comes to the dreaded termination of parental rights, after your child has been in foster care and your entire family has been denied access to any visitation or contact with your child without cause, they will say that there are no family members or anyone that is available to take your child and put your child up for adoption. But if you stand on providing this information, and each person who is able and willing to take care of your child while they are in care, while your case is open, make sure that this form is filled out, that the appropriate investigation and background screening is done, and that if they are denied, they have to provide a reason in writing why. So this is very important, and this is another form that we will go over in one of the next video series. Being supportive of your child in the place where they are receiving your care, telling your child it's okay to be where they are with the people they are with. Now, this is a tough one because you might not feel like your child is okay there. And, but you have to consider the impact of what down talking the foster parent or whoever the child is placed with will have on your child. They're going through enough. So it's very important for you to always, in your letters, in any visits, all your communications, don't question your children overly. Allow your children an opportunity to speak. And if you see something wrong, then gently question them. Make sure you're recording all interactions. If you're seeing bruises, if they're dirty, if they're hungry, if they are behaving differently than the child that left your care, then, make them feel comfortable, make them feel safe, but be very gentle and be very careful. The cabinet will remove your visits if they find out or they hear you asking questions or complaining to your child, or where your child can hear about the care and treatment that they're receiving. They will not investigate the foster home. They will remove your visits. Actively participating in your treatment and your child's treatment. Now, this goes back to the rights part. So, they want you to actively participate in your child's treatment, but they will not tell you where your child's being treated, when they're being treated, what their diagnoses are, what their medications are, what the challenges are that they are facing in between court dates. You will never know what is happening with your child because they will not communicate it to you. You have to stay in contact with them and specifically ask questions. Now, in this regard, I would say contact the guardian ad litem for your child and email them regularly and ask them, have you been to see my child? Do you have any information about my child? Stay in contact with all these people. Make sure that everyone involved in your case knows that you are willing, ready, and able to be there for all the doctor's appointments, all the mental health evaluations, any issues that come up during the care of your child. If whatever your case plan is, do your case plan plus a little bit more. Document all of your efforts and email, email, email. Make sure that these people know that you know what your rights are and you know what your responsibilities are. Communicate with your child's social worker and caregiver. Now, obviously, you're going to be communicating with the social worker. You're going to be emailing your social worker. You're going to be asking for, I would suggest doing it weekly. Hey, I'm checking in. Do my kids have a medical appointment or a mental health appointment? Has there been any change in their medical status or their mental health status? Have there been any behavior issues? When you completed your last home visit, did you take the letters that I sent with them? Did my child give any letters that I can come and pick up? Just keep it light, but keep it, be steady, be active. So, communicating with your child's caregiver. Now, technically, in the foster care program, the foster parents are trained by law to be as inclusive as possible and to communicate with the parent, but the cabinet will say it's not required. And it's technically not required. So, what I did in my case was made myself available to the foster parents. Here's my phone number, here's my email address. If you need anything, please contact me. You can call me anytime. You can text me. Here's my email. You can email me. Let me know if I'd like to sit down and have a discussion with you about my child's individual personality. I would like to be as involved as possible. Be friendly, be available, and continue. But if they characterize you as being aggressive or harassing the foster parent, you'll lose your visits, you'll lose all contact, and this label will follow you into the courtroom, and the judge will behave as though you are the hostile party. So you have to be very careful with your interactions. Providing financial or other support to your child as court ordered. Now, here's another tricky one. They will hit you with child support. Okay? Pay your child support. Because if you don't pay your child support, they're going to cast you in the worst possible light. In addition to that, if it gets down to the termination of parental rights, they will say that you didn't provide financial or any other kind of support for your children. Now, in my particular case with my family, I tried to provide, little things for my children: socks, underwear, electronics, books, toys. And I stopped because they were taken away by the foster parents as soon as my children got home. All the Christmas gifts and all of those things that other family members tried to provide weren't given to the kids. So hopefully, if you're lucky, your foster parent, in your case, your child's placement, will accept those things and allow those things to be shared with your children and won't remove them. I chose to stop doing it because it was more upsetting for my children to have these things and then have them immediately removed than if I'd never give it to them to begin with. But it will be held against me because they'll say, I didn't provide support to my child. I have provided support to my child, but these people are liable to say anything. And if you're already inside of a case, you know this. Attending all the scheduled visitations with your child and share information about your child with the caregiver. So that goes back to communicating with the caregiver. Initially, I was able to sit down and have a nice long talk about each one of my children's personalities, what worked and what didn't work with them as far as approaches and discipline and things like that, their particular food quirks, their medical information, anything that I could do to try to help my kids have an easier go of it while they are out of home. Um, if you do not attend your scheduled visitation, you will lose your children. Period. End of story. Um, they can be late, they can not show up, they can cancel at the last minute. You cannot. I don't care what you have to do. I don't care if you're getting fired from your job. I don't care if you have to hitchhike. I don't care if you have to sell plasma to afford an Uber to get there. Get to those visitations. Let's see, doing your part to remove the reasons why your child was removed to get your child back into your care. Now, each individual case is going to be very different, and there are so many reasons why children are removed. The biggest reason is neglect, which largely equals being poor. So, if they removed your child because they said there wasn't enough food in the house, start working on that. Find resources so that you can show that you can maintain that. If they remove your child from your care because there weren't enough beds or the house was dirty, if they don't provide you with a service to address whatever issue it is that had your child removed from your care to begin with, that started their involvement with you, then it is up to you to go out and find that, do it, document it, and provide it to the court. You can't just provide it to the cabinet. The cabinet's not going to report it. The cabinet's not going to say, look, this parent went above and beyond and did all of this extra stuff that we didn't ask them to do. They're just going to act like it didn't happen. They're going to play dumb. So you have to get this information into the hands of your attorney. So you provide the information to the caseworker, to the supervisor, to your attorney, and make sure that your attorney says so in court. Because all of these things, if any part of these things are neglected, when it comes time for a TPR, they're going to use this against you. So you can go through this pamphlet. It's 8 pages, as you can see. Let's see. There are going to be multiple court dates that you're going to attend throughout this process. So they'll have the temporary removal hearing at the 72-hour mark. Now, this court hearing is extremely important. At this point, they have done an investigation and they are submitting an investigative report to the judge. This investigative report should be supplied to you before you have this hearing. You need to have this information before you go into this hearing. The investigative worker needs to supply this to you before you go in. And the reason this is important is because they're going to give this investigative report to the judge. This is going to be their grounds for removing your children. They're going to determine, this court hearing will determine if there is evidence that your child was at risk of being harmed as a result of abuse or neglect. Your DCBS social service worker will notify you of the date and time of your hearing. You need that investigative report because the next video is the investigative appeal process. Now, your attorney may tell you that you have to stipulate to something or you're not going to get your kids back. That's not true. That's not true. You do not have to stipulate to anything to get your kids back. As a matter of fact, a stipulation to anything gives them one of the 3 elements that they need to terminate your rights. So very carefully question your attorney if they tell you that you have to stipulate, because there are additional hearings. You can choose not to stipulate and file an investigative appeal to identify any wrong information in that report and also present evidence to the judge that this is not true or this is not accurate, and lessen the amount of time or even defeat the removal hearing. So, all of these things are important. Now, you can go through here and read the rest of it. Your child may return to your care if the goals of your case plan are completed, if the reason for the removal no longer exists, if it's in your child's best interest to return to your care, or the judge releases the child back to your custody. Okay, case plans, I'll cover in another video. The reason for your child for the removal no longer exists, I'll have to go through that in another video. If it is in your child's best interest to return to your care. The cabinet has no interest in returning the child to your care. I don't care how many pretty words they write on their website. I don't care how many times they tell you that their goal is not removal, their goal is not adoption, their goal is reunification. What they are doing while you are in reunification status is simultaneously building a case against you for termination and adoption. It's called concurrent planning. So they already have a plan in place to terminate your rights and adopt your child out. And they are actively looking for adoptive placements while they are telling you that they're working towards reunification. That's why you have to document everything. You have to file these appeals. You have to question everything. You have to record. Okay? Now you can see here for Kentucky parents, here is the website where you can find this. It is a PDF. It is downloadable. It is printable. I would suggest that you immediately go here, you print this off, you fill out the top form, and it doesn't have a spot for the investigator's phone number and contact information, but the investigator is the one who's coming and questioning you. They're the ones that are going and questioning your children. You need to know if these encounters with your children have been recorded. If there's police involvement and the police are there, there is a body cam. You need to get your attorney to request that body camera footage so that you can review it. They can be very tricky when they question your children to get disclosures. In my particular case, they asked my 5-year-old son if he knew what drugs and alcohol were. When he said no, she told him drugs and alcohol were like cigarettes and beer, and asked him if he had ever seen anything like that. Well, I smoke cigarettes. So months down the road, they report that this child reported witnessing my substance abuse, when all my son said was, "My mommy smokes cigarettes." So it's important, if there is a police investigation and the CPS investigator goes and questions your children with law enforcement does have and should have on their body camera. You need that recording because they misrepresent and write the narrative to cast you in the most negative light. And even if they don't use that information now, they very well may further down the road, as they did to me. And that's it for today. If you have any questions, you can always contact me at parentpeergroup@gmail.com. And you can come take a look at our website at familyliberationfront.org. Thank you.